If I make a claim against my own automobile insurance company, will they drop me or will my rates go up? Hi, I'm Paul Hernandez, attorney at Kalfus Nachman, litigating cases across Virginia and North Carolina. This has to be one of the top 5 myths about when making an automobile insurance claim. Let me tell you how this comes up. Usually you get into an accident and the at-fault driver's insurance company is responsible to repair your car, to pay for your medical bills, your lost wages, your pain and suffering. But what happens when the at-fault driver does not have insurance, or the at-fault driver leaves the scene, as in a hit-and-run accident? It may come up when the defendant does not have enough insurance to fully compensate you for all of your harms and losses, and you have to make a claim against your own personal automobile insurance company, or against a relative of yours that lives in the same household with you. That last example is the one that most people have the biggest misunderstanding. Let me give you a quick example. You get into a real bad accident where you're hit by a drunk driver and have high medical bills and permanent injuries. The drunk defendant only has the minimum insurance required by law. You live with your parents who have a separate policy of insurance than you. You live with your brother and your sister who also have separate policies of auto insurance. Lastly, you live with your grandmother who also lives with you, and she also has a policy of auto insurance as well. Each one of those policies would apply to your accident. What did you say? You heard it right. Each one of those policies would cover you in the accident with the drunk driver. I will further explain how that works in another video. The important part is that your parents, your brother, your sister, and your grandmother will each say they do not want you to make a claim against their insurance policies. Why? Because they think that their insurance rates are going to go up. Listen closely. The reality is their insurance rates will not go up, and their respective insurance companies cannot drop them as a result of making an uninsured or underinsured motorist claim. You're probably saying, how can that be true? Probably because you're listening to an insurance company who does not want to pay claims, instead of a lawyer who's looking out for your best interests. The reason is, first, because your relatives were not involved in the accident and could not be charged in the accident. Virginia Code Section 38.2/1905 says, no insurer may increase its insured's premium as a result of a motor vehicle accident unless the accident was caused either wholly or partially by the named insured. Number 2, Virginia Code Section 38.2/2212 says, no insurance company can fail to renew your insurance policy simply by making an uninsured, underinsured, or medical payments claim on your policy. So, your automobile insurance company cannot raise your rates or drop you as an insured simply by making a claim against your insurance company. That goes for making a claim against a relative's insurance policy if they are a resident of your household. If you have any questions concerning matters or whether you even need to hire an attorney, pick up the phone and call me, Paul Hernandez, at 888-487-8546. And by the way, if you found this video helpful, Kalfus Nachman has dozens of informative videos on our website. So I encourage you to check out our video library to access more informative videos just like this one. I'm Paul Hernandez, and thanks for watching.